Hey everyone, it's Megan. I'm back with an update on Tory Lanez sentencing for shooting Megan Thee Stallion. The appellate court today denied his writ petition to disqualify Judge Hereford. And I got an email about 10:15 a.m. that I looked at about 8 minutes after it was sent that said the order was denied. The email had a link to the court website, so I clicked on it. You can see here that they say they're denying the writ of mandate and request for stay for failure to demonstrate entitlement to extraordinary relief. So that, like I said in another video, that's not really a surprise at all. This wasn't a legally valid excuse or argument really to disqualify Judge Hereford. You can see here the reasons they listed. They had three main reasons they wanted the judge off the case, and it was basically the way he structured and the way he treated them in the hearing last month for their motion for new trial. They were upset about a number of things, but none of it is anywhere close to constituting some kind of bias on the judge's part that would need or warrant any kind of recusal on that. So, I mean, this was just dead in the water from the very beginning, as I said. But I think it's a good chance to go over some times that I've actually seen judges recuse. Because, I've seen some people say, oh, well, she's not a lawyer. She's not the appellate court. How would she know about this stuff? But, I worked at the LA Daily Journal for 4 years. That's like the newspaper for lawyers. It's really well read by judges. And a big backbone of the Daily Journal is judge profiles. Every reporter does one judge profile a month, and you're responsible for looking at this big mega list that they have, master list that shows you who's contacted which judge and who's eligible to be profiled, because we try to profile every single judge in the whole state of California, and one can only be profiled every 7 or 8 years. At least that's how it was when I was there. So it was always kind of a hunt to find judges to profile, but you could profile appellate justices, federal judges, superior court judges, and I ended up profiling several appellate justices. I think at least 4 or 5, one in San Diego, 3 in Orange County, and then retired appellate justices who are then mediators, because in addition to the judge profiles, we would also profile mediators and arbitrators, people who are basically private judges who do civil disputes for JAMS, ADR, and other private groups like that, would get hired out by lawyers. Most of them are all retired judges, and some of them were retired appellate justices. So, I mean, I've heard all about the process, and I've covered plenty of appellate cases and just have a feel for how things work around there. So it was pretty obvious that this was going to get denied. And then, especially given my background of when judges have actually been recused, I've actually only seen it once. So I figured I'd go over some of those examples, or just some of the recusal motions that I've seen brought. But first, I did hear that Tory's sentencing is going to be delayed. The judge is going to grant the continuance request over prosecutor's objection, which I'm sure prosecutors are frustrated over that. And I saw some complaints from people online about it. But I mean, they wanted more time to file their sentencing memo for him. They haven't filed anything yet. And the way Hereford's been, I'm sure he just wants to give them time to do that and just make sure that he's not rushing anything. And it kind of goes back to what I was talking about, questioning whether he is really actually a bad judge for Lanez to have at sentencing, because I don't think a lot of other judges would allow these kind of continuance. And someone remarked to me that, public defenders must be mad about this because they don't usually get the continuance requests that granted that Jose Baez and Matthew Barhoma are getting. But I did hear that the sentencing is going to be delayed. They don't have a date yet, but it should be probably early July, or maybe they'll give them a couple weeks. Maybe it'll be late June, but we'll all know on Tuesday. Everyone's still going to have to go to court because Lanez will have to verbally agree to the continuance again. So that will be another just kind of a big spectacle for just another delay, which we've had a lot of. But I wouldn't be surprised if Judge Hereford says, this is the last delay, no more delays, and then sets the date. So it also will be interesting to read Lanez's sentencing position. Like I said in this article here, prosecutors are asking for 13 years in prison. They want 6 years for the first degree assault conviction, and then an additional 7 years for the enhancements, the aggravating circumstances of great bodily harm, and the use of a gun. But it's also heavily focused on the campaign of misinformation they say he's waged against Meghan in the 3 years since the shooting, and just his attempts to humiliate and re-traumatize her, and then his disobedience of court orders associated with that, and then also the assault of the singer that I talk about here in that article. So that's all here at legalaffairsandtrials.com, so be sure to check out those articles. But while we're on the topic of judge disqualification and recusals, I thought it'd be a good chance to go over some of the other cases that I've seen. The examples that I've seen of recusal motions and judge disqualifications have come in both state court and federal court. As I said in this article that explained Tory's original disqualification request and the writ petition, there are two types of ways to just qualify a judge in California. One is 170.1, the other is 170.6. And 170.6 is automatic. It allows one disqualification per case. And it causes a lot of griping amongst the judges because the attorneys actually have to sign something saying that they believe the judge is biased against them or their cause. And they're saying that attorneys sign that basically lying when they sign it, that they just don't like the judge, they don't like the rulings, they don't truly believe there's a bias. So there's a gripe in that amongst the judges. As I explained in the article here, the Riverside County judge complained about it at a conference that I was just at. But one thing I learned through the Daily Journal coverage is that it's such a big city thing, this thing to disqualify a judge. It's, of course, a big issue in Los Angeles, in Orange County, which are these big superior courts within California. But one good thing about the Daily Journal was you got to talk to judges all over the state. So while I've profiled appellate justices and federal judges and trial judges in Orange County, I've also profiled, interviewed people who know them, judges in really small counties up in like Northern California. I remember I interviewed a judge and talked to people who knew him up in Trinity County, where all the weed growers live. And it's such a small county. He was one of like 2 or 3 judges or something like that. And he talked about how it's not like you can really recuse yourself from a case, that, you know, he has cases involving like parents of kids who are on his son's soccer team, and it's just something that you see around. You're just kind of bound to see all these people around town. It's such a small area. So the whole concept of these judge recusals is very unique to kind of the big court systems like LA in Orange County. And it's also very unique in that federal court does not have these automatic judge recusals. You know, they would just think that's crazy. The federal judges, the fact that in superior court, you can just within 10 days of your case being assigned, if you want that judge off the case, you can get the judge off the case. Superior court, of course, I said that there's kind of whispers that there's a system set up that allows it so litigants who use the 170.6 almost get punished by getting sent to a worse judge. But in federal court, it's just not allowed. But there is a system to try to bring a recusal motion against judges. And we saw a big high-profile example of that through this Wall Street Journal article, this big investigation that the Wall Street Journal did in conjunction with the Free Law Project that opened up public access to judges' financial filings that listed all their stock interests and things like that, because there's actually a law that prohibits judges from handling a case that they have a financial interest in or stock interest in, like that. And then there's also the separate law governing federal judge recusals that would basically prohibit something like that with a financial interest. So they caught 131 judges had examples of handling cases that they basically shouldn't have because they had stock interests. And the fallout from that article was a lot of judges looked at their own stock interests and then were like, oh, look what I did, and notified litigants in past cases that, like, hey, by the way, I had a stock interest in this case. And some litigants took issue with it and tried to do recusal motions. And I covered, or maybe not recusal motions because the cases were over, but they tried to get the orders that the judge issued thrown out. And there was an example down in San Diego federal court that I covered for law.com. You can see the article here. It's archived through Bloomberg and LexisNexis, which just shows how, legit we were. But it was Janis Sammartino. She had also been accused of not fully disclosing her interests in the in the stock. She disclosed 3, but the attorneys here were saying there were actually a couple more that she found, and they wanted a class certification that she'd done actually overturned. And class certification is when you hear that there's a class action lawsuit filed. It's always, I think, kind of an error to just call it a class action lawsuit when it's just been filed. A lot of people will add the word proposed in front because that's a very important word legally, because you can't just automatically file a lawsuit that has a class of plaintiffs attached to it, like you represent this group of injured people. You can only say that you want to do that, and then there's litigation over how the class is certified, and it's up to the judge to certify the class. So she had ended up, this judge in San Diego had ended up certifying this class of tuna suppliers. And this is an antitrust lawsuit against tuna companies, basically alleging that they were colluding on prices and trying to rip off the tuna suppliers like Target, Amazon, other stores like that, Costco. So this judge in San Diego had certified this class of 5 tuna suppliers, and then she'd actually notified the defense in the case. The same day she actually transferred the case to another judge, she sent out a notification saying, oh, by the way, it turns out I have stock interest in some of the litigants in this case, some of the parties in the case. So the defense, which is represented by Latham Watkins, that's like one of the biggest law firms in the country, they basically freaked out and demanded more information about her stock interests, and then moved to decertify the class. And it turned out that she had 2 other stock interests beyond what she disclosed. So they were writing letters to the clerk of the court, her clerk, demanding more information, trying to get answers, acting super frustrated. And then they bring this motion to decertify, which was the basis for my article here. And they had a pretty big order that was on their side, because the judge's colleague had actually reversed a summary judgment that the judge had issued in another case, because it turns out that her family had stock in MetLife, which was a party in the case. She'd granted summary judgment in MetLife's favor. So because it turns out that she had a financial interest in MetLife, that all got reversed by another judge. And I mean, that's pretty embarrassing. It's kind of a big deal. So Latham definitely felt like they had things on their side here, going in to try to get the class decertified that she'd done. It was part of an appeal that they had in already, but the Ninth addressed this issue specifically, and they said that they actually sided with the judge. They said she had no disqualifying interest when she certified the class, because she actually, the companies that she had stock interest weren't part of that certification. They had said that they didn't want to be part of that. So it's like she didn't actually have any financial interest in that certification. And the Ninth even kind of scolded the defense attorneys for bringing this when they did, and said that there was a delay in bringing the case, and it said it raises the appearance of gamesmanship. So that's not an example of them having to bring a disqualification motion against the judge, but it is an example of just the conflicts that arise within the judiciary and the issues that judges go through, especially her getting that summary judgment reversed. The Ninth sided with her on this one, but the summary judgment reversal was a pretty big deal. And I always love writing about those things within the judiciary, because I think they're very undercovered, and they're just, it's very interesting because it shows how human the whole process of the judiciary is. I do have other examples of recusal motions being brought and rejected, like Lanez's was in state court against Judge Hereford. And Lanez's attorney's motion actually really reminded me of a recusal motion that was brought against, he's actually a famous federal judge. He was probably one of the most famous federal judges as of late nationally, Judge David O. Carter. He has his chambers in Santa Ana, and I've covered tons of his cases over the years. I can't even say how many times I've been in his courtroom, how many trials I've seen him do, how many hearings I've seen him do, how many jokes I've heard him make, and in all that. I've gone on a tour of homeless camps in Skid Row with him and another reporter and a bunch of other people, and so I know him very well. And as I said, he was probably one of the most famous judges in America over the last couple of years, because he did the January 6th case involving John Eastman's emails. He was a lawyer for President Trump and really involved in the January 6th stuff. And he was a professor here in Orange County at Chapman University. So the January 6th committee was trying to get his emails from Chapman University, and John Eastman sued to stop it. And the case actually went to Judge Carter. So Judge Carter ended up issuing some pretty major rulings. One that actually said that Trump and John Eastman more likely than not committed crimes in relation to their stuff to try to overturn the election in the January 6th insurrection that went down. Or the attempted insurrection that went down. So he got tons of attention from the January 6th committee for that. But it was kind of funny when it happened, because I did a profile on him for law.com that was just about how everyone was so excited in Orange County when he was getting so much attention, because everyone's known him for so long. But he might be the most likely in federal court in the Central District of California to have a recusal motion brought against him. It used to be Manny Riel. He was a judge for 50 years up in Los Angeles, a famous judge who died a few years ago, and he was actually Judge Carter's mentor judge, but he was constantly getting removed from cases by the Ninth Circuit. Maybe not constantly, but getting removed from a case by the Ninth Circuit is extremely rare overall in the judiciary. It just doesn't happen very much, but it happened quite often with Manny Riel. He stayed on the bench until he was 95. He actually had senior judgeship when he died. But I don't have an example of Carter being removed from a case, but I have not by the Ninth Circuit. I have an example of a current request into the Ninth over one of Carter's colleagues that I'll get to. But I do have a few examples of recusal motions just at the trial level against Carter. One which was granted, which was a very big deal. It was granted by another judge. But the one that reminds me of Tory's recusal motion against Judge Hereford was brought last summer by a woman who said that his courtroom was like a rough military boot camp, which is maybe an exaggeration, but Carter's a former Marine and he keeps very long hours. So the attorney was very upset about the way he'd handled a trial that she did. She is suing the Sheriff's Department, the Orange County Sheriff's Department, on behalf of a Marine veteran who was assaulted by sheriff's deputies at O'Neill Regional Park, which is here in South Orange County. And she's had 2 trials now. But after the first trial, which I watched a lot of, she brought a disqualification motion against him, describing his courtroom as a rough military boot camp and actually citing harsh treatment that actually caused her to cry in court. The trial ended in a mistrial. This was last September after the jury couldn't reach a verdict, and Carter actually delayed the retrial a couple of times. So she was upset over the fact that he had scheduled her retrial so far in advance that she said that she couldn't afford the delays like that, and said that the judge had shown impermissible bias and prejudice, which is the standard that you need to establish to have a judge recused, or have him show that it could show the appearance of that. She said that he basically doomed her case by delaying it so much that witnesses were, their lost memories were becoming an issue, and it was also just becoming cost prohibitive for her to bring this on. But she said, she writes in the motion, "If this is the price my client and I had to pay for bringing suit against the Orange County Sheriff's Department, known for its corruption and brutality, it's too heavy of a price." Defense attorneys said in their opposition briefs that she had no legal basis for the recusal, and they disputed key claims like her assertion that Carter had several times resumed trial before she'd returned to the courtroom. And they also had a different take on his overall approach to her, basically saying that he was too accommodating to her and that she had so much unprofessionalism that she was given far more leeway than she should have been given. And they say any fair reading of the transcript reflects a patient jurist who, like everyone else in the courtroom, was left astounded by her needlessly combative and frankly contemptuous tone, according to a brief that they filed in opposition to her recusal motion. And as I explained in the article, it says U.S. law calls for federal judges to recuse themselves if they have personal knowledge of a connection to a case or if their impartiality might reasonably be questioned. And Carter had actually self-recused on a case before. I have an example here, and I remember just him talking about this with me when the case happened, because I was actually covering this as a freelance assignment for my friend who was the editor of the Laguna Beach Independent, and he lives in Laguna Beach. But a civil rights suit was filed by a school district employee of the Laguna Beach School District. She was suing the district over a school board issue, them shutting her out of the school board. It was some complicated local thing. And it actually got assigned to Judge Carter, but he recused himself. And in the recusal motion, he cited his personal friendship with many of the named parties. So the idea that judges don't do that, I think there are probably very, not a lot, but other examples of judges self-recusing like that, or recognizing that they know someone that, in the case that they were randomly assigned and trying to get off it. But motions to actually disqualify federal judges aren't usually granted. But allowing judges to decide their own recusal motion was actually not something that the Central District used to do. They had changed that policy to become more in line with every other federal court district in America. Apparently, pretty much every other district has the trial judge decide their own recusal motion, and they have the option of giving it to another judge if they think is necessary. So the Central District changed their system to have it that way a couple of years ago, but before that, the Central District had actually had it so it went to another judge. And Carter had a recusal motion brought against him by attorneys for 3 cities in South Orange County that were run by conservative people who don't want to build any kind of homeless shelter down there. And Carter had lawsuits that he was managing for a bunch of cities up in North Orange County. There was a huge homeless encampment near Angel Stadium, the baseball stadium, that Carter led this effort to dismantle it and find homes for people. The county was going to dismantle it anyway, and some people sued to stop it, and he got the lawsuit, and it ended up taking this really unorthodox approach to everything, where he actually took everyone down to the riverbed and did his own tours of the riverbed because he wanted to see everything down there himself instead of just hearing testimony about it in court. So he was out there all the time. There are all these photos of him leading the charge out there, and he did all this great work kind of mediating the case and helping establish this social services homeless system for the homeless in Orange County that wasn't in place before. But the South Orange County cities, these 3 cities, don't want anything to do with that. They have all these reasons for not wanting a homeless shelter down there. So when they got sued and the case went to Judge Carter, they had hired Jones Day, which is another one of the biggest law firms in the world, and they brought a recusal motion against Carter based on all these statements that he'd made in the litigation about North Orange County, stuff about bad mayors. He had invited South Orange County to come to the table in that lawsuit and negotiate. And he made a remark that, if they didn't, they were bad mayors. There's other examples here too in the of why he was recused. I remember I did a story on this for the Los Angeles Daily Journal. So my story was very technical and detailed. Unfortunately, I can't bring up a screenshot because you'll see the Daily Journal is so paywalled, but I do have the old text of the article here. So Judge Carter had actually described his approach as non-judicial to the settlement with the North Orange County cities. So Judge Selna, who got the recusal motion, he's another judge that I know really well. He did Michael Avenatti, the thieving lawyer who's now in prison. He did his criminal case, and he also did T.I. and Tiny's OMG Girls case, but he was the one who made the decision to recuse Judge Carter. His order basically says that Judge Carter made these decisions before he knew the cities were going to be involved. And it says the district judge bears no fault for the present circumstances, but the court concludes that he likely gained access to information and had contacts which would be impermissible to the present action, given the city's lack of consent. And that's this ex parte communication, as the legal term is called, for when a judge goes off and does his own conversations without all litigants present. And in the case with the North County cities, they'd agreed to let him do that, but they hadn't agreed to that with the South County cities. So Judge Selna ordered him off the case, and it was a really big deal. I remember when the order came down, when an attorney in Orange County called me, and he was just like, wow, this is so juicy. It's like Judge Selna recusing Judge Carter, you know? But it hasn't, I haven't seen it again because, like I said, they changed the system so that judges now consider their own motions. And I did another article on that for law.com, but everybody had all these, different reasons for supporting it. So I have some examples of judges actually rejecting their own recusal motions, like Judge Hereford did in Tory Lanez' case. And the first one is another recusal motion that was against Judge Carter, actually in a pretty interesting case involving a young guy who was accused of trying to provide material support to terrorist groups, including Hamas. He was a former Marine who was arrested a couple of years ago, and they found a bunch of guns in his house, and then they had a bunch of internet records that showed him communicating in these chats with various terrorist groups. And they actually tried to get Judge Carter recused from the case because a magistrate judge who's not a lifetime appointment judge like Judge Carter is, magistrate judges in federal court are actually appointed by the federal judges to serve 8-year terms. And they handle things like discovery disputes over evidence. And then in criminal cases, they'll do the arraignments and bail hearings, set bail, decide if somebody should get bail or not. And the magistrate judge in this guy's case had set bail. She was saying that he was a good candidate for that. And Carter actually revoked it, and they ended up appealing the decision to the Ninth Circuit. And so the court ordered Judge Carter to provide better reasoning on that. And then actually, after he filed something, said that it basically wasn't good enough and ordered the guy released on bail. So after all that happened, the guy's lawyer actually tried to get Judge Carter recused from the case because Judge Carter is a former Marine, was in the Vietnam War, has a Purple Heart. He was badly injured. He's basically a war hero from that. And she cited the judge's own service in the Marines and said that it contributed to a military-based bias and resulted in him making hostile comments toward the defendant because she'd actually quoted him saying, "And you planned on leaving the military, which you're entitled to do, because the U.S. Army are terrorists, and so are the Marines." And he was being, sarcastic. I can totally imagine him saying this, because obviously those comments would really offend him. He read in the affidavit the comments that the defendant was accused of making about the military, U.S. military, calling him terrorists. And of course, Carter wouldn't like that. And just knowing him, he must have just been in one of his moods, because he just laid into this guy. And the guy's lawyer writes in a recusal motion, "These comments by Judge Carter were not due to reading from an exhibit presented before the court, but rather from the judge looking at the defendant during the hearing and mocking the defendant's opinion, as stated in chats contained in the government's discovery. Judge Carter's attitude toward the defendant belies a hostility that a fair-minded person could not entirely set aside. And so she's referring to a U.S. Supreme Court case from 1980 about judge recusals, the whole could a reasonable person or could a fair-minded person set this aside. Prosecutors argued that Carter's comments were completely supported by the record, and the judge declined to leave the case. He issued a 3-page order saying his determination that the guy was an unmitigated danger to the community was based solely on the overwhelming evidence and not a personal bias. So the defendant's lawyers actually appealed Carter's denial of the recusal motion to the Ninth Circuit, but the court rejected the appeal for lack of jurisdiction because the order is not a final judgment. So I was expecting them to pursue an appeal if their client was convicted at trial, and I just thought this seemed like an interesting issue. It's not like that previous recusal motion where the attorney was upset that Judge Carter made her cry and didn't like the hours of the trial. This one seemed to maybe have a little bit more merit to it, but the trial that happened ended up ending in a mistrial because the Bratz billionaire, the billionaire CEO of MGA Entertainment, was on trial down the hall against T.I. and Tiny in the OMG Girls, OMG Dolls case. And he knows Carter from way back 10, 12 years ago when Carter presided over the Bratz versus Barbie doll trial that Isaac Larian, the MGA CEO, was so involved in. And he likes Carter from that. So he went down to the trial to say hi to Carter, not knowing that there was a trial going on. And it actually turned out to be during closed testimony because this was a national security case with the terrorist organizations involved. So there was certain testimony that was closed to the public. But in the Bratz billionaire's defense, it's not like the courtroom was closed. There was no sign on the door, so he didn't know. So he just goes in and sits down he's waiting for a break so he can say hi to Carter. And it ended up causing a mistrial because his presence in the courtroom and then being asked to leave brought the jury's attention to these restrictions that were in place that they weren't supposed to know about. So there was a mistrial. And then instead of going on trial again, the guy ended up taking a plea deal. So because of that, I don't think we're going to be seeing any kind of an appeal unless Carter imposes a sentence, because the guy hasn't been sentenced yet. So if Carter imposes some kind of a sentence that's way beyond the range or something that's beyond what prosecutors are asking for, or if the defense wants to appeal the prosecution's sentence recommendation that Carter imposed, we could see some kind of appeal over that recusal motion. Maybe it could be brought up in the appeal, but I think it's pretty much dead in the water. Another recusal motion that I saw was actually brought against Judge Cormac Carney, who's in the same Orange County federal courthouse as Carter and Judge Selna. But for a while, he was chief judge up in Los Angeles. He actually resigned after a short while as chief judge because he had described the court clerk who's black as street smart, and it ignited a lot of controversy. And the way he responded just kind of exasperated the whole thing. He kind of dug into it and just ended up resigning. It got a lot of attention. There was an LA Times article about it, and a criminal defendant who's black brought a recusal motion against him based on the comments. And Judge Selna actually is the one who reviewed it and just said that he didn't think that the comments reflected its self-bias on a racial basis toward the court employee blacks or people of color in general. And it kind of reflected the controversy within the courts about the controversy over Carney's comments. I think Selna was kind of indicating there that he doesn't think it was that big a deal, but he definitely indicated that he didn't think it warranted any kind of recusal on a case. I know of another recusal motion that Judge Selna handled. It was regarding Judge Josephine Staten, who was in Orange County for a long time and is now up in LA, and he rejected it. It was brought by attorneys who were upset, apparently, that her husband is part of a law firm that was involved in the case. But Judge Selna says here that the history of their efforts to recuse her suggests both an absence of good cause and an absence of good faith, which, well, that's not good. But they said basically that they'd known about this for a while and that they sought to recuse her on the theory that her household had a financial interest in the outcome of the fee dispute that was between her husband's law firm and the other law firm, the law firm trying to get her recused. But it says that they'd failed to learn before filing the motion that Prell, her husband, was not a partner at the time of the fee dispute, thus negating the premise of the motion to recuse. The intentional effort to create a conflict of interest does not amount to good cause, nor would the interest of justice be served by entertaining such a brazen effort to manipulate the assignment of this case. And I think that last statement really speaks for a lot of judges on what they think of these recusal motions, the kind of forum shopping, the judge shopping that you see. And the state judges and all these judges that I just mentioned were once Superior Court judges, so they're very familiar with the 170.6 process, the automatic recusals that you get in state courts. So obviously Selna was expressing his distaste with that practice there, that kind of just blanket practice of trying to recuse a judge just to basically shop around. So there are other examples. One interesting thing about these recusal motions is it's not like we get press releases when they're out. I mean, if you're already tracking a case and you're getting notifications about the filings and there's a recusal motion, you're going to get a notification about that and hopefully recognize the significance of it and do a story on it. But other than that, there's a way to set up notifications in Court Listener for certain topics or certain codes that are being cited. So I should get one set up for the recusal motions. But, there's been recusal motions kind of come and gone that I'm sure I've missed that would have been a good story. But one other way to recuse judges, and not really recuse them, but get judges removed from a case in federal court, is the appellate court can actually order a judge off of a case. And like I said earlier, they used to do it pretty frequently to a judge named Manny Riel, who died, who was Judge Carter's mentor. I haven't seen it with other judges, but the DOJ, the U.S. Attorney's Office in L.A., actually have a pending request in regarding Judge Carney, Judge Cormac Carney in Orange County for it's over a case that he's dismissed. It's a drug case against a doctor who's accused of basically being a drug dealer to his patients, some of whom died. The indictment has been dismissed a couple of times by Judge Carney because it was supposed to go to trial during the pandemic, and the court had shut down jury trials. The majority of the federal judges in LA voted to shut down jury trials, and Judge Carney didn't agree with that. He thought it was unconstitutional, so he dismissed a few criminal cases because he thought that delaying the trial indefinitely was unconstitutional. So it was appealed, and the Ninth Circuit overturned him, and he was basically upset that the Ninth overturned him and said that they got a bunch of stuff wrong that they actually didn't, and ended up, instead of obeying their mandate to take this case back and adjudicate it, he dismissed it again so he could write another opinion basically saying why the court got their reversal of him wrong. So that's currently under appeal, and the DOJ in their appeal formally asked the Ninth Circuit to remove Carney from the case, which is a big deal. I wrote a story about it here on Legal Affairs in trials.com a few months ago. I've heard that Judge Carney has actually since said that he's taking senior status and leaving the bench completely. He's not taking any more cases. He doesn't have his notice formally in to Congress, but I'm thinking it will be soon. So that'll negate the issue. If he just leaves the bench completely, they'll have to reassign it to another judge. So other than that, I mean, recusal motions being granted at the trial court level and federal court are really uncommon. And we also don't see a lot of judge removals from the Ninth Circuit either, or other federal circuits. I just think the recusal issue is so interesting. One thing I wanted to address was this came up today. I like everyone else saw Dennis's tweets about he heard there's going to be an arrest warrant, or there is an arrest warrant over threats against a blogger issuing death threats or something. And when I saw it, I was just like, huh? I mean, like everyone else, I don't know anything about that. And I had people like adding me trying to, oh, you got to get to the bottom of this. It's like, no, I've got actual real news to look into. And honestly, my first reaction was I really doubt the DA's office would actually file criminal charges over some online threats. I mean, I don't know. I haven't gotten anything that I've ever thought that I needed to report. But so I don't know. Like I said, I was pretty busy yesterday on this Danny Masterson case, the judge sanctioning the attorneys for Scientology, leaking discovery to Scientology. It's a big deal. You should check out the story on my website. So, I mean, I didn't have time to like respond to some rumor, but then when I'm going on YouTube, like I'm trying to do, I'm trying to get more active on here. I see the live thing being like, oh, is Meghann Cuniff getting bloggers arrested? It's like, what even is this? I'm like, my first reaction was, God, I don't have time for this. Like, what even is this? I don't have time to like watch that. What? I also thought about how there's a saying in journalism. If the headline is a question, you can basically just assume the answer's no. So no, I am not getting bloggers arrested. And one thing that struck me about it is the people who are doing this, at least one of them has been like, oh, why don't we get the respect that you get as a journalist? It's like, well, maybe because I'm a journalist and you're just like spouting rumors and gossip online and kind of couching it as, oh, well, I didn't actually say that was what was going on. I just raised the question. I mean, when I saw the headline pop up on YouTube that he was going live, I was like, oh, they're reporting the fact that I just reported that Tory's bid to disqualify the judge was rejected. You know, some breaking news here. And then I look at it and it's like, oh, is she getting bloggers arrested? It's like, I mean, I was a little stunned that they would do that without even attempting to contact me. Like asking me if it's true, giving me some chance to respond. I mean, this is basic fairness stuff, guys. Like, come on. It's like, you see all this stuff and it's like, oh yeah, gee, I wonder why you don't get respect as a news reporter and journalist. You know, those headlines that you write where you can't even spell my name right when my name is all over the internet. Come on, people, at least spell my name right if you're just gonna run all these gossip and rumors about me. But one thing that I just think is funny about this whole thing is that I honestly don't really think I have any kind of valid claim for like harassment or anything like that against these people. Threats. I've never really felt threatened by anyone. And if there have been death threats or something and I've missed them, I'm not sure if I saw them, I would feel actually threatened. Like if I can look outside my window right now and not see one of these malicious bloggers, like, you know, in my window after me, I think that's a pretty good sign that I'm not actually being harassed and that no kind of court action or police action is needed here. And, you know, the idea that I would go out running and filing police reports about people, like, guys, my dad was a criminal defense attorney. I grew up in Corvallis, Oregon. I just think it's all a little overblown. Like I've definitely felt the heat in the replies. It's like, wow, these people are crazy. But that's what the mute button is for. That's what the block button is for. I mean, the idea that it's ever reached the level of like valid threats or real harassment, it's like I don't think so. And I mean, I just, as long as it's just online and you're able to block people and it goes away, I mean, there's nothing to be concerned about. I mean, in the end, none of that stuff is worth my time. It's not worth filing a police report over. It's not, I mean, there's no valid claims. I mean, the idea that you could sue somebody for this, it's like, I don't think there's any valid, like, defamation lawsuit, harassment lawsuit. No way. It's like, not that, like, these people are even contacting me in person. But another thing is, the whole idea of suing somebody is like, you're gonna recoup damages and get money from them. So usually you sue people who are insured, or, I mean, lawsuits are like big wars between insurance companies. It's all about the insurance companies. So I'm assuming most of these people who are just like viciously talking shit online don't have like big insurance that will like back some kind of like harassment settlement. They'll just like have to declare bankrupt. I mean, the idea that these people have any money to like pay in damages or something is kind of funny. But I go back to my first point of that there's not any like valid legal claims or something. So I just had to laugh over that, because like I said, my first reaction was like, oh man, I don't have time for this. Like, I'm trying to get this article done on the Danny Masterson case, because I went up to LA for the hearing yesterday, but it was after I did the Tory Lanez 13-year recommendation story. So I stayed up really late doing the video and the story for that. And then I got up super early so I could go up to LA for the hearing. So I was just kind of exhausted after the hearing, and I didn't get the story done. So I wanted to get the story done Thursday morning pretty early, because I knew that it was kind of making the rounds. Like, James's story was out and the AP had picked it up, and it was being picked up everywhere. So I just saw this like police report. I'm like, what the heck? I don't have time for this stuff. But oh man, it's amusing. But like I said, I'm doing the YouTube thing, or I'm trying to. Tory is supposed to be in court next week, but like I said early on, the prosecutors say it's going to get delayed. Judge Hereford is going to grant him another continuance so they can get together their sentencing package, which overall, I mean, like I said, the defense attorneys, the public defenders are probably mad because they never get these kind of continuances. But I think it goes back to the fact that Judge Hereford's like really probably not that bad of a judge to have for sentencing. He was a criminal defense attorney for 20 years, and he wants to hear from Lanez's lawyers on their sentencing position. And I think there's a real chance, even after all this, even after the recusal motion, that they could get him to impose something less than the 13 years. Because, like I said, I don't think any judge, and especially Hereford, is going to like punish the criminal defendant for the recusal motion. The recusal motion was silly. I mean, Hereford thought it was silly, but it's not like it ever had any chance of being passed. I mean, the appellate court stuff was dumb, but I don't think he's going to like punish Tory or give him more time in prison or something because that happened. He wants to get the sentencing papers and read them and see what's going on and figure out what he's going to do. I'm interested to see what date he's going to set for this. Well, basically for my own scheduling purposes, because right now without a date, I don't feel like I can schedule anything. Like, I can't go up to Yosemite or anything because I don't want to miss the sentencing. So as soon as that's out, I'll be tweeting out the news. So, and I'll also be doing more YouTube videos. So subscribe to my YouTube, check out legalaffairsandtrials.com, and I will see you all later. Thank you.